Human Rights Bureau presentation on retaliation. Although retaliation and discrimination complaints are two separate types of complaints, retaliation is proscribed under Montana's anti-discrimination laws and federal anti-discrimination laws. As such, the Human Rights Bureau is tasked with investigating complaints of retaliation as well as discrimination. Retaliation has been for some time and continues to be the second highest filing that the Bureau receives each year. Retaliation is statutorily defined and is different than the dictionary definition of the word and what most people understand as retaliation. The Merriam-Webster definition of retaliate or retaliation is to return like for like or get revenge. However, the definition under the state and federal anti-discrimination laws is much more specific regarding the reason or motivation behind the revenge taken. The Bureau only has the authority to investigate complaints of retaliation that allege that a respondent took a significant adverse act against a charging party because that person engaged in a protected activity. Anti-retaliation provisions are found under both the Montana Human Rights Act and the Governmental Code of Fair Practices. Combined, these statutes prohibit a person, educational institution, financial institution, governmental entity, or state or local governmental agency from discharging, expelling, blacklisting, or discriminating against someone in any fashion because he or she engaged in protected activity. The language of these statutes provide that protected activity is opposing any practices forbidden under the Montana Human Rights Act or the Governmental Code of Fair Practices, which in essence is opposing discrimination. The statutes also state that filing a complaint, testifying, assisting, or participating in any manner in an investigation or proceeding of allegations of discrimination is protected activity. It should be noted that when the statute states it's unlawful for a person to retaliate, the Montana Human Rights Act defines person very broadly. The statutory definition of person means one or more individuals, labor unions, partnerships, associations, corporations, legal representatives, employers, organizations, and employment agencies. This broad definition is important because it widens the scope of who can be liable for taking retaliatory actions. You may have noticed that the statutes pertaining to retaliation mention that it is unlawful to retaliate against someone for opposing practices forbidden under this chapter. What are those forbidden practices? Well, those chapters outline very specific forbidden practices, such as the requirement for an employer to return a female employee to work in a same or equivalent position after maternity leave, or the prohibition of notices or advertisements for housing that indicates a preference or limitation based on protected class to whom housing will be sold or rented. However, forbidden practices more generally mean unlawful discrimination, which is when someone takes an adverse act against an individual in a protected area because he or she is a member of a protected class. The protected areas of anti-discrimination laws are employment, public accommodations, governmental services, housing, education, insurance, and financial transactions. So for example, if someone complains that they were refused a loan because of his or her race, that is opposing discrimination in the protected area of financial transactions. The discrimination being opposed must occur within one of these protected areas to be considered protected activity. Here you see the protected classes under federal and state laws enforced by the Bureau. In order for an action to be discriminatory, not only must it be taken in a protected area, as reviewed in the previous slide, but the action must have been also taken because of the person's membership in one of these protected classes. In a previous example, someone complained they were denied a loan based on race, so race was the protected class. Another example is if a girl complains to her high school that she is treated differently than other students because she is from Morocco, which places her in the protected class of national origin and the protected area of education. By making that complaint, she has engaged in protected activity. However, if a girl complains she's treated differently at school because she has blonde hair, which is not a protected class, such complaint would not be protected activity because the actions being opposed are not based on a protected class and are therefore not discriminatory. When a retaliation complaint is filed with the Bureau, this is the initial analysis it uses to determine if a charging party can establish a prima facie case of retaliation. Prima facie is a Latin term that means on its first appearance. The charging party must prove each element of a prima facie case to show that what respondent did, the adverse act, looks like retaliation on its first appearance. The first element requires the charging party prove that he or she engaged in a protected activity. Next, the charging party must show that he or she was subjected to a bad act by respondent. And lastly, the charging party must prove that there is a connection between his or her engaging in the protected activity and the significant adverse act taken by respondent. Now let's look at each of these elements more closely. In order to analyze whether or not a charging party satisfies the first element of the prima facie case for retaliation, you must understand what constitutes protected activity. Protected activity includes opposition, participation, and requests for accommodations. We will now look a little closer at each protected activity. There are three things to understand regarding opposing discrimination, the forbidden practices we reviewed earlier, as a protected activity. Opposition puts a respondent on notice, it is done in good faith, and it is done reasonably. Opposition can be protected even if it's informal. A person does not have to use magic words like protected class, harassment, or discrimination. At the Bureau, we look at it from the perspective of whether the charging party said something to the respondent that put the respondent on notice that the charging party was concerned about something that would fall within the Bureau's purview. Said another way, is the charging party voicing a concern that the Bureau might be interested in? As an example, if an employee says to his boss, "I think I'm getting paid less than Tori. She's younger and started after me and I trained her up." That is a complaint that an employee feels treated less favorably than someone who is younger. This statement is opposition to possible age discrimination. Accordingly, an employee making such a statement has engaged in protected activity. But to the second point on our slide, if you're opposing something, you have to oppose in good faith. The protection for opposition is limited to those people that act with a reasonable good faith belief that the conduct opposed is unlawful or could become unlawful if repeated. So what if a woman complains to her boss that she doesn't like that her coworker asked her out on a date? Well, this one act may not legally qualify as sexual harassment, but the coworker could possibly continue on a path that would become harassing if left unchecked. Therefore, the woman's complaint of an incident that could manifest as sexual harassment would be protected activity. If her employer's response to her complaint is to put her on the worst shift possible just to get her out of the way of the offender, that may be retaliation for her complaint. Let's now take a moment to talk about reasonable opposition, because reasonable opposition is different than good faith opposition. If you're going to oppose discrimination, you still have to do it in a reasonable manner. If your manner of opposition is unreasonable, you may end up giving your employer a legitimate, non-retaliatory reason to take an adverse act against you. For example, we had a charging party file a complaint at the Bureau who works in a bar, and when her boss called in to talk to her while she was at work, she started a bit of a tirade, yelling at the person who answered the phone that she didn't want to talk to their boss because he was a racist. Yes, the charging party complained about discrimination by saying that her boss is a racist, but it wouldn't matter if she was complaining about discrimination or the cost of cocktail napkins. You holler that in front of patrons and employees, there's probably going to be consequences. The Bureau recognizes that a charging party may not prevail on a complaint if it was brought in bad faith or if the manner of opposition was not reasonable. The next type of protected activity is participation. Respondents cannot punish a person for filing a complaint, serving as a witness, or participating in any other way in an investigation matter, even if the underlying discrimination allegation is unsuccessful or untimely. This has been interpreted to include participation in an employer's internal complaint process as well, even if a charge of discrimination has not yet been filed. The third and last type of protected activity is requests for accommodation. Requesting an accommodation for either a disability or religion is a protected activity in the area of employment. An example of a request for religious accommodation can be your Native American employee asking for time off to attend a powwow. Request for an accommodation for a disability, much like retaliation, is complex and an entire separate training topic on its own. But for now, just understand that a request for an accommodation is when an employee expresses to his or her employer a need for a modification or change at work due to a mental or physical health condition. For example, if an employee requests time off to seek out cancer treatment, that is a request for accommodation for a disability. If the employer then schedules that employee for an unfavorable shift or discharges him because he requested time off for his disability, the employer retaliated against the employee. Once it's established that a charging party engaged in a protected activity, he or she must next prove that the respondent subjected him or her to a significant adverse act in order to satisfy the second element of the prima facie retaliation case. A significant adverse act is one that would dissuade a reasonable person from engaging in a protected activity. The administrative rules of Montana provide a non-exhaustive list of possible actions that could amount to a significant adverse act of retaliation, including violence or threats of violence, intimidation, discharge, demotion or denial of benefits, expulsion, denial of privileges or goods at a public accommodation, eviction or other action that adversely affects availability of housing opportunities, or a denial of credit or insurance. Although these examples include tangible employment actions, significant adverse actions can be much broader in scope. For example, in the area of employment, an employer could take a significant adverse act in retaliation against an employee exclusively outside of work, such as a supervisor starting an altercation with an employee at a company picnic because the employee made unfavorable statements about the supervisor's discriminatory actions during an investigation into discrimination. The third and final element of the retaliation prima facie case requires the charging party to prove that there is a causal connection or nexus between the protected activity and the significant adverse action. Evidence that may support there is a connection include suspiciously close timing between the protected activity and the adverse action, or proof that respondent intended to retaliate against charging party by way of comments by the respondent or witness statements. If a charging party is able to satisfy all three elements and prove a prima facie case of retaliation, then a shifting burden analysis is used. Once the charging party meets the burden of proving the prima facie case, the burden then shifts to the respondent to produce a legitimate, non-retaliatory reason for the adverse act it took against the charging party. Once the respondent produces that legitimate, non-retaliatory reason, the burden then shifts back to the charging party to prove that the reason proffered by respondent is pretext or unworthy of belief. In order to prevail on a retaliation complaint, a charging party must prove his or her case by a preponderance of the evidence. This means that retaliation more likely than not occurred. This standard is less onerous than beyond a reasonable doubt or based on clear and convincing evidence. Rather, it is a 51% probability based on the evidence at hand that discrimination occurred. A preponderance of the evidence standard is the same standard used by courts reviewing retaliation cases. So what type of evidence helps a charging party overcome that last hurdle in the shifting burden? What shows that a respondent's reason for challenged conduct is pretext or unworthy of belief? Any evidence that tends to show that the proffered legitimate, non-retaliatory reason is false can lead to a charging party prevailing on a retaliation complaint. Witness statements that bolster a charging party's position or impeach a respondent's reasons for taking a significant adverse action may prove pretext. Also, comparative data can help disprove a respondent's legitimate, non-retaliatory reasons. For example, the Bureau had a case where a salesman opposed discriminatory conduct by his supervisor and thereafter was disciplined and eventually terminated for not consistently using the company's software tracking system for sales calls. He only entered his numbers on the system here and there. The comparative data showed that another member of the sales team One who had not engaged in protected activity had not used the software at all for months, failing to record any activity, yet that team member received no punishment. This inconsistency in the respondent's actions towards its employees when meting out discipline proved that the employer's reason for disciplining the salesman and terminating his employment were pretexts to retaliate against him for engaging in protected activity. As mentioned earlier, witnesses reporting that the respondent made statements of an intent to retaliate against charging party may be evidence of a causal connection between protected activity and an adverse act. But what if a respondent says, writes, emails, or texts such a statement directly to the charging party? That would be direct evidence of retaliation. It is important to note that the Administrative Rules of Montana change this analysis a bit in the event that there is direct evidence of discrimination or retaliation. When there is direct evidence, there is no shifting burden, but rather, respondent must prove by a preponderance of the evidence that an unlawful motive played no role in the action it took against charging party. Alternatively, respondent can prove that the direct evidence is not credible and unworthy of belief. An example of direct evidence of retaliation would be a landlord telling his tenant, "Maybe next time you'll think twice about filing a complaint with HUD against me," when the tenant asks why he's being evicted by the landlord. In addition to direct evidence, there is another way a charging party can get around having to prove a prima facie case of retaliation. If a charging party has a complaint of discrimination or retaliation at any stage of the administrative process with the Department of Labor and Industry or in court, and with knowledge of that complaint a respondent takes a significant adverse act against charging party, the respondent will then have to overcome a disputable presumption that the adverse action was retaliation. The disputable presumption is also created for any significant adverse acts a respondent takes against a charging party within 6 months of the final conclusion of the complaint of discrimination or retaliation as well. Like in the case of direct evidence, this means that a respondent will have to prove by a preponderance of the evidence that its actions were not retaliatory for the complaint filed against it, instead of the charging party having to prove a prima facie case and pretext by a preponderance of the evidence in order to prevail. As an example of how the disputable presumption works, consider the following case. A charging party filed a complaint with the Bureau alleging sex-based discrimination against her employer. A few months after that case concluded, the charging party filed a retaliation complaint asserting that her employer retaliated against her for the previous complaint by ignoring her during staff meetings and informing her when management was meeting with the attorney who represented the organization for her discrimination complaint. Because of the prior discrimination complaint filed by charging party and her allegation that the adverse acts occurred within 6 months of the conclusion of that first complaint, a disputable presumption was created and respondent had the burden of proving that its actions were non-retaliatory. Even with this presumption, charging party was unable to prevail on her retaliation complaint. Although charging party felt she was being treated differently after her initial discrimination complaint, ultimately she was unable to prove that the acts she asserted were retaliatory either occurred as she stated or that they rose to the level of a significant adverse act. It's interesting to note that an individual can also file a complaint for an adverse action taken against him or her because of an association with or relation to a person who is engaged in a protected activity. This type of complaint is referred to as by association complaint. Although retaliation can occur in any of the protected areas under anti-discrimination laws discussed earlier, the area of employment sees the highest number of retaliation cases year after year. With that in mind, here are some suggestions for best practices for preventing retaliation in the area of employment. First, after someone engages in protected activity, make sure there is clear communication of expectations. Don't simply expect everything to spontaneously return to normal. Second, routinely educate and train your staff on both discrimination and retaliation. Third, promote a highly visible and vigorous grievance system for retaliation claims. Fourth, Ensure leadership commitment to the anti-retaliation environment. 5th, seek independent input and oversight for decisions that may impact a person that is engaged in protected activity when possible. And 6, monitor the environment. Would you like to learn more about retaliation, discrimination, or the Montana Human Rights Bureau? Visit our website at www.montanadiscrimination.com or give us a call toll-free at 1-800-542-0807. You can also call us locally at 406-444-2884.